Abisha for me sansu mo wi akwa ba shonko pa esabe your Odame TV. Say na your first time, I kindly add your subscription, your likes, your comment, you share our videos, and please click on the notification button for more news updates. So in case of any update, I wanna be a first person now so because it's a particular news no. So yes, ye free bibi say nole prosecute na eno chere say nsem a ewo nsem ni bi wo ha ekoso ewo court ewo Ghana ha say ya nipa o ana say attorney general okrum ha say na agent say on focus on that particular case. So cases ni bi wo ha wa ba to egu but you heard these cases most of them also across lost to the states. Any sika kiti sika emuyedu. First of all, Alhaji Collins Georgia. Only sika our course say $200 million. There was also Dr. Stephen Kwabna Opuni, former CEO in the send inti and Mama Babetna Stephen Opuni. Also Ghana ka 271.3 million Ghana cedis. This year or the B account and 30 million Ghana cedis and now so into Mama Babetna. The next one and next no claiming is software abagana business sika basika esombo 178.9 Ghana cedis ebesina eno software neswa the next person so young kasa to force the majority leader or parliament this year or also sika or board Ghana 2.3 million euros ebisha for also the also for ambulances and I say ambulance abagana eno amba ambulances wa ebi baye ebi empty ebi so amba a whole lot enekoso oh my God must na papa ya your friend or Dr. Kwabna Stephen Opuni ebisha for ono the nesiam no a bit critical because time before so obey the CEO former CEO for Cocoa Board no a CEO for Food and Drugs Authority no ho no oye bibi na any kwise oye eno na sisia asama no abo on my Ghana ka 13 million Ghana cedis na ni nyina ne se okọ clinic se or say Tobinco a drona or no papa you know Tobinco the trend of my Ghana say eku enkora fana e my Ghana say meanwhile as same way our can say Tobinco nra or produce e my Ghana say eku nkrani bino na ye any scientific researcher back that allegations now or make it against Tobinco no osa carry or see debi say yan share in drone out Tobinco a producing na ebe koso ekunkra bebre e wo mangana say eno na man for and I said Tobinco pharmaceuticals for atina sidin who say yeah papa sabi was sabotage you know that was destroy your reputation and your part was sense so be can we in na che yan na that means we don't know and there now no na onye under the influence of alcohol no we need that or you knew what you were doing but oh yeah so Sisiana we for court of appeal as a pija some way now data same way as about the reason of CCR the current attorney general for Ghana Dr. Dominic Ayuni or CCR all the cases are Ghana for able to go or but because even CCR say okasatia ye president the current president Dr. John Dramani Mahama ye be fine obi sika a emuyedu but CCR no kan ho ne kwetiensem na hodo emu chimu every the audio behind this particular video you so now or subscribe to Odame TV, you share our videos, you click on the notification button, you comment and then also you like, okay? Yeah, you're going to see with us.
As far as what the court is looking at, the standard is that you have to establish it beyond any reasonable doubt. That means you have to establish it 100%. If you say Paul Ademochi has done X, you have to establish it 100%. If a doubt is raised, so that your ability to establish it is dropped from 100 to 99%, the accused is free. You have not been able to establish the case against the accused. When you bring an accused person, they are not asking you to establish the case 40%, 50%, 60%. They want you to establish 101%. That is beyond any reasonable doubt. That's how it works. That is the law that we have inherited from Magna Carta, 1216 AD. Magna Carta, which is the Human Rights Bill, the main Magna Carta is in Latin. The main human rights bill is called the Magna Carta. You can Google it. Those people who like to Google, Gen Z people, Google MAGNA, Magna Carta. It's a Bill of Rights. Or you can Google the Bill of Rights. It will come. It was in 1215. Maybe I'm getting 12. Maybe it's 1237. Maybe it's 1220 something. But it's 12 something. Way back at the time Oxford University was established, this principle was established in criminal jurisprudence that where an accused person is being accused, first, the standard of proof should be high. 1215. Yes. It's 1215. Magna Carta, 1215. I read it way back in government. When we're doing government, A-level government. So sorry, I'm old. So when I say A-level, I know people can relate to it. A-level government, Magna Carta. We used to joke with it. Then we have nicknames. Some of the boys, we call them Magna Carta because they would chew the thing the whole night. Viewers, we learned, and we are happy that we did. So Magna Carta is 1215 BC, yeah? And it's established the Bill of Rights. Okay. So in that Bill of Rights, it is guaranteed that an accused person should be allowed to defend himself with everything that he wants to defend himself with. So if an accused person says that the person who knows the matter that I have to tell the court is Mr. Paul Adumotri, he lives in London and he's not able to find money to come, the prosecution system, the court system would have to find money to bring Paul Adumotri down for him to come and say the thing that the accused person says. It is only Paul Adumotri who knows this thing, and it is only him who can give this information to the court. If the court gets this information, they will know that I'm innocent. If that happens, the courts, it is an obligation on the court to organize for the said Paul Adumotri to come from England to come and testify. That is the extent to which the law goes to protect the individual. Okay, they are giving me disclosure. It means that I'm spending too much time on the introduction. I'll move on very quickly. So this is the matter. Atacha comes to court and says that I want a discovery. So there's because of this right that is embedded in Magna Carta, which runs through all criminal jurisprudence. Because of that right, when I say jurisprudence, I mean the body of legal theory that governs criminal prosecution. That's what jurisprudence means. You can Google that as well. Jurisprudence is a Latin word again. Juris means law, prudence means prudence, yeah? Okay. All right. So because of that, the law has granted an application called discovery. Now, the application called discovery can be applied by defense counsel, lawyers for the defense. That application can be applied by them if they feel that the material that they will use to defend themselves, it is in the possession of the accused person or the government. So, for instance, X is being prosecuted, like Kwabena Dubois is being prosecuted. And then they've seized his passport. So his passport is at the CID. And then he says that I need the passport to be able to show you, not even that, that's not a good example. Kwabena Dubois is being prosecuted, and he says that on this matter, Serem Sai cannot speak about it as Deputy Attorney General because that time he was in America. And then they say, yeah, Deputy Attorney General, you were not here, you were in America, so why are you speaking as if you were here? He says, I was here. They say, no, you were not here, you are lying. Now his passport is with him. It's not with me, it's with him. Now, the process of discovery allows the accused person, the lawyer for the accused person, to apply for discovery and tell the court that compels Serem Sai to bring his own passport to the court that we can ascertain this matter. That's what discovery is about. So discovery recognizes that the accused person may need some material that is in the custody of the prosecution who are more powerful than the accused person. And therefore, the prosecution does not have the power to go and search accused person's house. They don't have the police. The defense does not have the power to search the prosecution's house. The defense does not have police. They don't have immigration. They don't have CID. They don't have airports. They don't have anything. They just have themselves and the law. So the rule of discovery is that where the defense counsel, so emasculated by their role as defense and their hands are cut off, that's what I mean by emasculated, they can apply to the court and tell the court that this material, it is in the hands of the prosecution. They should bring it. Because the prosecution will now be asked to bring something from within their fold that will be used to challenge their own case. So they may be resistant in doing so. So the legal system brings about the rule of discovery, that counsel can apply for discovery that this person should bring it So that we'll use against him. With that background, let's look at the meaning of discovery, and I'll show you what has happened in the Court of Appeal today. Black's Law Dictionary's 4th edition says, discovery means the disclosure by a party of facts, titles, documents, or other things which are in his exclusive knowledge or possession and which are necessary to the party seeking the discovery as part of a course or action pending or to be brought in another court or as evidence of his right or title in such proceedings. It's written for lawyers, so don't worry about the repetition and the punctuations that are made to settle everything. So that's discovery. The learned counsel for Kwabena Dubois, Atachia, was shocked to the bone and marrow when he found out that a bank statement, and you know this Kwabena Dubois thing is about banks, a bank statement has been brought to the court by Prosecutor Sremsai. He brought a bank statement to the court. When he brought the bank statement, about 70 pages of the bank statement had been taken out. And he brings bank statement of only page 2 to the court. And then Atachia says, but I've not seen some of this before. What is the meaning of this? Where is the rest of the bank statement? Because we need the rest of the bank statement to make our case that whatever allegation you are making is unfounded. So long as you can produce the entire bank statement, we will show the court. Sremsai says, I can't give you the entire. How do you bring a bank statement from Advantage company, Kwabena Dubois' company? You publish their banks. You know that he's the owner. He also has a bank statement. But you publish the bank statement in the court, and you publish only small and leave the rest. I mean, viewers, how callous can people be? How wicked. You want to by force jail the guy. And you think you have the courts. By force, they want to jail him. Because how do you explain this thing? And that's why it was useful for an application to go for this trial to be shown on television. As for this Kwabena Dubois trial, it pains me that it's not on TV. It should have been on TV for everybody to see the disgrace and the embarrassment that is happening to our local jurisprudence. It should have been on TV for everybody to see. How do you say that an accused person cannot be entitled to a bank statement, the full bank statement, but you only want to bring 2 pages? Atta was beside himself with anger. The judge said, Atta can go on with the case. He doesn't need those bank statements. That's the judge's opinion. Atta was outraged. He filed to the Court of Appeal. This is a high court trial. He goes to the Court of Appeal where 3 judges are looking at it. And again,